Mr. Cicada, I'd like to start with you, if that's all right. I believe that the elimination of the $200 National Firearms Act tax stamp was a significant victory for Second Amendment rights. This is a constitutionally protected right, the right to bear arms, and when we attach a significant tax burden to it, that's got to be taken into account. Now, unfortunately, that didn't eliminate all laws that might fall, under the same argument. We still have pretty significant restrictions in place, including various registration requirements that exist under the National Firearms Act, not all of which I believe have clear constitutional justification. But even before we get to the constitutional justification, which may tie in to the policy points, I wanted to ask you a little bit about whether and to what extent or in what way there is, law enforcement or other policy-based justification that makes it, compelling, makes it make sense, makes it necessary for one reason or another to have these restrictions in place as to things like silencers, short-barreled rifles, and short-barreled shotguns. Can you think of good policy-based law enforcement justification for having those on the books?
Good morning, Senator. Thank you for your question. As far as policy, our enforcement of those firearms applies strictly under the NFA. If, let's say, for example, they weren't under the NFA, they would still be required, they would still be firearms under the GCA.
Right, so they're not unregulated. And in order to buy them, you would still have to go through the background check process, which is, which is significant. And depending on how busy they are at the time when you're buying a firearm, you may have to wait minutes, or it might be hours, or whatever it is. But it's not completely unregulated at that point.
That's correct.
So these are additional restrictions slapped on top of those restrictions already applicable to all firearms. Is that right?
Yes, sir. Through the NFA, that's correct.
Okay. Now, and that certainly, grasp that certainly as to the short-barreled rifles and short-barreled shotguns. Let's talk about suppressors for a minute, the sound suppressors, commonly known as silencers, but, a technical term within the industry is sound suppressors. Tell me what policy justification. I think that one falls as legitimate as the criticism is of these restrictions as to the other items that we've discussed, like short-barreled shotguns and short-barreled rifles. It seems to me to be particularly difficult to justify the additional restrictions as to sound suppressors, because sound suppressors are themselves not guns, correct?
Under the law, sir, suppressors are considered firearms under the Gun Control Act. So that's why they're regulated under the GCA. Well, they're regulated under both GCA and the NFA.
Right. But unlike actual guns, the suppressor is not capable of firing a bullet. Unlike guns, suppressors are there, as the name implies, to suppress sound. So that people who use guns, whether that's for hunting, for target practice, for sporting of one sort or another, they are subjected to a bombardment of sound that is louder than it otherwise might need to be. And for people who use certain kinds of firearms that happen to be really loud, they've got to use some kind of hearing protection on their ears. The question arises, what decent public policy justification or law enforcement need might compel the United States government, with all the force of the United States government and with enforcement power given to the to ATF, to restrict those, given that there is a legitimate public policy justification for actually wanting to encourage people to do it, because it tends to protect people's hearing. Can you think of any good reason why we should not allow those, or at least why we shouldn't allow them without this additional step above and beyond what applies to firearms generally?
Again, sir, from ATF's perspective, ATF is bound by the law at this point, and if Congress chose to move suppressors out of the NFA into the GCA, ATF would be supportive of Congress's decision.
Well, that is very good to know, because we periodically do introduce legislation, and when we do that, with basically every department, every agency I'm familiar with, we tend in my office, and I think my colleagues do the same, to seek technical input from the agency involved in the enforcement of that law. And it's good to know in advance sometimes what that might look like. So I appreciate your perspective on this one. Congress does need to revisit these issues, particularly given that sound suppression can be very important for health and safety reasons. There is not a legitimate health and safety reason, certainly, to treat this not just as a firearm, but as a particular type of firearm that requires further restriction.